I'm truly delighted to introduce our eminent speaker tonight, Professor Guy Goodwin-Gill. As you probably already know, he is a leading light in refugee law. It's always topical to talk about refugee law in Australia. Our policies have been so controversial over the last 25 years. But perhaps a very appropriate occasion to talk about refugee law tonight as we think about what will the Commonwealth Parliament do in relation to those sick children and their families currently on Nauru, and as we've witnessed the negotiations of a global compact on refugees through the United Nations system. Guy is currently a Professor of Law at the University of New South Wales and was Acting Director of the Caldor Centre for Refugee Law from 2017 to 2018, while our very dear colleague, Professor Jane McAdam, was on leave. He has held numerous appointments at very prestigious institutions, in particular Oxford. He's Emeritus Fellow of All Souls College, Emeritus Professor of International Refugee Law at the University of Oxford, and is currently an Honorary Associate of the Refugee Studies Centre, which is quite possibly the oldest centre and certainly a wonderful interdisciplinary centre that looks at refugee issues. In addition to holding these very significant academic appointments, Guy has had a very productive career as a practitioner. He practiced as a barrister at Blackstone Chambers, London from 2002 to 2018, specialising in public international law, human rights, citizenship, refugee and asylum law. He represented pro bono the Office of the UN High Commissioner for Refugees as intervener in a number of appeals in the UK House of Lords and Court of Appeal. He's been counsel for refugees and asylum seekers in the UK Court of Appeal and Supreme Court, and he has also acted in the International Court of Justice and at the European Court of Human Rights. And he's no doubt also, his bio doesn't say this, but given opinions on legal issues in many, many jurisdictions. And I can remember Guy being involved in the Timorese test cases here in Australia many years ago. So he's made an enormous contribution as a barrister, and I think that really reflects a commitment not just to think and write great thoughts about refugees, but to actually use that incredible body of knowledge to assist the people that we write and teach about. His scholarship is enormously influential, and I'm just going to talk about a couple of highlights. He's the founding editor of the International Journal of Refugee Law, which is undoubtedly the leading journal in the field, and was editor-in-chief from 1989 to 2001. And that may have been the first time I came into contact with Guy, because he helped me publish one of my doctoral pieces of work. And I have very fond memories of being mentored and encouraged to do better as I published that work. He's both prolific and certainly publishes well beyond refugee law. So he's written on issues like child soldiers, child rights, the international law governing the movement of people between states, as well as refugee law. But I suspect he's best known for his work in refugee law, particularly for what I'll call the Bible. He's the author, along with Professor Jane McAdam, of a leading treatise, The Refugee in International Law. Currently third edition, but I understand there might be a fourth on the way. No pressure, Guy. And if you haven't encountered that book, I really highly recommend that you do read it. It's just compulsory reading for anyone who wants to understand this complex and ever-changing area of the law. So, having given you a few highlights of Guy's remarkable career and probably embarrassed him a great deal, I want now to invite him to the podium to present on his topic for tonight, which I think you can see up on the screen there. Please join me in welcoming Professor Guy Goodwin-Gill.
Thank you very much indeed for those warm words of welcome. I am delighted to be here and to meet up with Penny again. I must say we've been, both of us, working in this field for so many years we were not going to count them. I didn't know Michael Whincop, but I do know from what I have read of him how committed he was to legal scholarship, to rigorous legal scholarship. And I like to think that that is something to which I also attach great weight, even as I, almost daily these days, regret the numerous occasions on which those making the law on refugees and migrants seem determined to ignore the lessons of scholarship and to ignore the evidence of that other great body of law, international law, which is the primary field in which I've been working for many years. I want tonight to look at the question of principles and purpose, and to the challenge of stepping up to refugee protection in this era of displacement. And here, as we know, sovereignty is an issue. No one challenges the right of the state, or the right indeed of every community, to decide central issues of membership within the limits of principle, any more than its right to adopt the political, economic and social system of its choice. But sovereign states which are sovereign, independent and equal, to use the language of the United Nations Charter, themselves exist within a community of other sovereign states. Then the conundrum lies in the fact that between asserting sovereign rights and then carrying them through commonly demands a measure of cooperation with others, not necessarily compromise in the banal pejorative sense of short-term political thinking, but in simply recognizing that other sovereign states have interests. For example, it's all very well and good to witter on about the duty of every state to readmit its citizens, and to imagine that's an end to the matter. But there's a real world out there where life is not quite so simple, where one state's irregular migrants are another state's natural resource, even a critical income stream when abroad. And there are cases, of course, when return is simply unacceptable from the perspectives of risk and harm, or where it is impractical or impossible, as is often the case with stateless persons. So sovereignty in its extreme unilateralist form is an obstacle, and it's commonly an obstacle also to achieving the humanitarian and other objectives for which states establish the UN and its various agencies. And hence, as we know, the difficulties of preventing genocide or ethnic cleansing, most recently in Myanmar, or bringing to account those responsible for these and other crimes under international law. I'm afraid I always like to start talks about refugees by going back to the League of Nations. And that's what I'm going to do tonight. Where can refugees fit then in this world of sovereigns? In 1921, no one in Europe knew what to do with refugees, and you might think nothing much has changed since. But the very idea of the refugee in 1921 seemed anomalous to states. They lived in a state-centric world which was only then just beginning to engage in international cooperation across multiple fronts. Everyone, it was assumed, should be a national of one state or another, and every state should be responsible for the diplomatic protection of its citizens abroad. Remove the protection element, and imbalance resulted. The displaced and their displacement challenged basic premises about the relations between states, and it was particularly their being without protection rather than the causes of flight that engaged attention. Of course, politics were never very far away, especially as in the 1920s, when the Soviet Union, then considered to be a rogue regime, was concerned and was seen as responsible for the lack of protection of refugees abroad. But it's a time in which initiatives were taken, and they were taken promptly. The first High Commissioner for Refugees was appointed in 1921 as well, Friedhof Nansen, and he recognized right away that refugees needed and wanted to work, and that keeping refugees off the public purse was critically important if government and public support were to be maintained. He was supported by states. States recognized also that protection had to be provided, not only to replace that diplomatic protection which had been lost through rupture with the country of origin, but the protection also against return to the risk of harm, what we call today non-refoulement, and protection considered as equal treatment as near as possible with nationals, so that the refugee exiled from his or her country of origin could integrate successfully. And certainly the 1920s saw some progress in dealing with successive refugee groups through very often simple administrative matters like issuing identity certificates. But come the 1930s and we find a decade where things more or less stood still for the League of Nations as a whole, and not just for refugees. It even went into reverse to some extent as hundreds of thousands fled the end of the Spanish Civil War, the rise of fascism in Italy, and active persecution under Nazism. Now, at the risk of oversimplification, I see these moments of stumbling ineffectiveness as being due not only to inherent weaknesses in international organisation, and they were many, but also to states' failure to question their preliminary assumptions. Because in 1921, when the Red Cross turned to the League, it was not just because the resources for humanitarian assistance were dwindling, but also because major political issues were engaged, which called for a political response that only the League could provide. Fridtjof Nansen, too, saw the limits of policies confined to aid, and he urged long-term strategic thinking instead of the ad hoc approach preferred by states for what they tended to assume then, as they often do today, that refugee problems are just temporary and will soon go away. There were good leaders in those days, in the sense that they could see what was going on. In December 1935, one of Nansen's successors, James Grover MacDonald, who was High Commissioner for Refugees coming from Germany, brackets Jewish and other, he resigned precisely because the deep political question underlying the refugee exodus from Nazi Germany, the causes, was not being addressed. And as he said, there are limits to what can be achieved through humanitarian assistance. Now, this experience of the League, and of course the experiences of World War II, led actually to one brief, bright moment of unanimity in the United Nations before the refugee question came to be overtaken by Cold War politics. And in February 1946, states in the General Assembly unanimously agreed that the refugee problem was indeed an international one, in the sense that no one state should have to bear the responsibility on its own, that any state admitting refugees, as it were, on behalf of the international community, should be entitled to call on others for assistance, whether moral or political, material or financial. But the problem then, as now, would lie in translating this call among sovereigns into predictable outcomes. But the principles of solidarity and of responsibility sharing underpin the regime to this day. One distorting consequence of that East-West divide, nevertheless, was that weight and importance were attributed to the refugee. In fear of persecution, the victim of the other, our existential enemy, the Soviet Union and its allies, that other had voted with their feet or voted by boat, and none during the period of the Cold War was ever turned away. Today, however, the refugee no longer has political value, except to those perhaps who would capitalize on the threat which those in flight are said to be. And humanitarianism, it seems, is just not enough. In fact, there is nothing in the world of people moving between states that cannot be managed effectively, humanely, in accordance with international law and consistently with those principles of protection which have consolidated over time within our international institutions, and in many, if not all cases, within our national conceptions of rights and due process. And speaking as an international lawyer, it is that practice over decades that enables us, as advocates, as international lawyers, to speak with confidence of the right to seek asylum, though the road may be fraught, of the right not to be refooled, sent back to harm, of the right to claim protection and to be heard, of the right not to be penalised for illegal entry or presence, of the right to be protected against torture, cruel or inhuman and degrading treatment, of the right of the child in flight to decisions that take due and proper account of his or her best interests, that do not rob the child of their childhood or damage their physical or mental health, or otherwise deny them in the short time available of the opportunity to prepare for a meaningful life in community. But, and there's always a but, isn't there? But as refugees have continued to move between states, as the movements themselves have become mixed in with migratory streams, and as secondary movements from places of first, if insecure, refuge added to the momentum, states lost their grip on principle and purpose, giving in to the deficiencies in international organisation that had been anticipated from the start but never adequately addressed, the gaps in the system of obligations, the missing links in the scheme for international peace and security. And first among the challenges are the causes, once again. As MacDonald pointed out, the drivers of displacement, persecution and conflict, compounded today all too often by underdevelopment and the impact of climate change and disasters. Second is the quest for solutions in all their complex linkage to causes themselves. And third is the task of somehow at the national level fitting policy and practice on issues seeming to bear on national identity within the framework of international law and obligation. And as we can see all too well, the international community, the United Nations and its member states, is just not very good at preventing conflict. And I often ask myself, as I'm sure many of us do, could the Sri Lankan civil war have been avoided? Or that in Somalia, or South Sudan, or Syria? And once underway, could more have been done to mediate a peaceful solution? And what of persecution, of government-sponsored ethnic cleansing in Myanmar, or of non-state violence in Central America, or the complex intersecting drivers of displacement in Venezuela? Couldn't something be done? But likewise, governments do not seem to be particularly good either at staying focused on the search for solutions once the refugee movement has taken place. They're not particularly good in promoting the conditions conducive to voluntary repatriation, in supporting local integration and the host communities that take in refugees, on ensuring resettlement for those in need. Indeed, it still seems to me that many states are simply only too ready to hope for the best, to ignore the human dimension, to ignore the hunger for a future for family and self that is no less a part of the refugee's experience than it is of the human condition. For refugees are not, and never have been, just the passive recipients of largesse from the global north. Yes, they are frequently constrained to live in camps and settlements with limited freedom of movement and few opportunities. But refugees remain agents in their own destiny, and it is hardly surprising that so many have felt compelled to move on from first refuge because of continuing insecurity and absent the prospect of return or any meaningful life in the medium term. This is a much more mobile world than it once was. It is replete with information and opportunity, and where there are desperate people, as we know, so often also there are others ready to help, ready to capitalise. And current and recent crises of displacement, I'm thinking in particular of Europe and the Mediterranean in 2015, 2016, these secondary movements were always predictable in their occurrence, if perhaps not necessarily in their numbers. But state thinking seems not to have moved on. Despite 70 years of the United Nations, over 55 years of UNHCR and the 51 Convention, and now nearly 100 years of international refugee law, organisation and practice, many of the old preconceptions are as deeply entrenched as ever. Among them, the assumption that refugee situations are temporary and exceptional, that much displacement is more voluntary than forced, and that sovereignty and control over borders is alone sufficient to ensure unilateral solutions. Australia's experience, sadly, is a lesson to the contrary. And of course, the movement of people has always caused apprehension. But instead of investing in and in strengthening host communities, many governments have raised or sought to raise barriers to movement. Few, though, have stopped to think seriously about what it is that leads people to take risks for themselves and their families that you and I would hardly dare. We do have an international legal regime. It's centred around the 1951 Convention relating to the status of refugees and its 1967 Protocol, now ratified by some 148 states. It is often criticised but little understood. It was never intended to prevent the necessity for flight, but nor could it. Neither did it anticipate all the challenges to state competences in migration that would come to dominate the 21st century agenda. Only in 2016, that's 70 years after that seminal resolution of the General Assembly in February 1946, only in 2016 did states come to see migration, like refugee movements, as an international issue, the better management of which is beyond the capacity of any single sovereign state. But what the Convention did, what the 51 Convention did, was to recognise the refugee as someone of international concern who needed special protection. That recognition, of course, drew on experience. The drafters, after all, had been witness to persecution and the Holocaust. Although increasingly today I think we may need, for empathy's sake, to factor in a more contemporary understanding of the complex multiple reasons that compel flight and generate sympathy. The Convention also sets out a body of rights, both to facilitate the integration of the individual in the country of refuge, for though it may not be permanent, the status of the refugee is necessarily indefinite, not just temporary. We can never know in advance when it will come to end. And these are rights in the Convention which are there to ensure the refugee's security against penalisation for illegal entry, against expulsion, against return to persecution. But they balance these rights against state interests as well. State interests were accommodated, and the Convention excludes from protection those who are undeserving, such as war criminals or threats to security. At the same time that the Convention was being drafted, the General Assembly decided to establish a subsidiary organ, the Office of the UN High Commissioner for Refugees, with a universal responsibility to provide international protection and to work with governments in seeking permanent solutions to the problem of refugees. And it was this agency, UNHCR, that sent me here in 1978 as a legal advisor to represent UNHCR on the then established Determination of Refugee Status Committee. So my association with what goes on here is also long-standing, and I remember those years, 78 to 83, as quite a different country. The architecture, the international architecture, has of course evolved. It's evolved into the present-day international refugee regime, but organisationally and legally it was and is unfinished. There is a right to seek asylum, but no obligation to grant it. There is an international obligation to cooperate in solving humanitarian problems, but UNHCR cannot impose solutions. International law defines the refugee and certain fundamental rights, but it leaves open critical issues. Which state is responsible for deciding claims for protection? What principles, if any, govern the movement of refugees and asylum seekers who have not yet found effective protection and solutions? What practical responsibilities do states owe to others receiving refugees in terms of financial or material support? States had the chance to firm up their commitments in 51, but they chose not to do so, seeing the gap between non-refoulement and asylum as much in their interest, perhaps, as the dependence of the international system on voluntary contributions. And in the absence of a fully functional refugee protection and solutions mechanism, in a context complicated by the frequently chaotic and ineffectual workings of a migration system driven by unrealisable unilateralism, states frequently seek, as you might expect, to maximise self-interest, in particular by displacing responsibility onto others. And that tendency, of course, has been helped by local politics, itself influenced by the apparent incompetence of government on the one hand to manage borders securely, and on the other to respond with coherent policies and practices that produce principled solutions nationally and internationally. Australia and many other states are now facing and will continue to face the challenges that arise from the movement of people. We are witness, sadly, to the bankruptcy of unilateralism, not perhaps sadly, we are witness to the bankruptcy of unilateralism, of short-termism, and of policies rooted not in evidence but in attitude, of the willful disconnect among politicians and policymakers from the realities of globalisation, conflict, poverty, climate change. Lucy Mangan, reviewing a book in The Guardian last month, wrote of, and I quote, "The intransigence of officialdom, blessed by its eternal ignorance of ground-level suffering and the arrogance that enables it to dismiss the calls of experts." Was she writing of refugees? No. Was she writing of climate change? No. She was writing of the flu that killed 50 million after the First World War, but the disconnect was no different then from what it is today. And getting an evidence base into the management of refugees and the displaced remains an uphill struggle. Now, when we look at Australia, we find a mixed record. Australia is renowned for the resettlement policies and practices which it introduced in the aftermath of the Second World War, when the Department of Immigration, under various guises, saw itself very much as a nation-building enterprise. It was involved also in the negotiations leading to the 1951 Convention, and its ratification of that treaty in 1954 brought it into force. But like the other major immigration and resettlement countries, like the USA and Canada, Australia thought at the time that the Convention would have very little, if any, actual impact on its sovereign competence to decide admission. After all, it was still very far away. But it was the Indochina refugee crisis that changed all that, even as it brought me to Australia. A slow trickle of asylum seekers arriving by boat on Australia's northern shores began in the mid to late 1970s. And the government's response was prompt, positive, practical, and simple. It reflected the political need to reassure the people of Australia that it was in control, that everyone who arrived was checked as their reasons for flight in accordance with international refugee law. And as Claire Higgins has shown in her book Asylum by Boat, egregious policies such as interception, turnbacks, indefinite detention and the like were categorically rejected as un-Australian. While the policy and practice adopted at that time also signalled a measure of solidarity with parties in the Western Alliance, and more particularly with countries of first asylum in the near region. All that would change and morph over time into costly incoherence and inhumanity, driven by xenophobia, and I must say a certain paranoia about arrivals from above, stoked by media keen to profit, encouraged from within by the increasing recognition that there were no legal limits to executive extremism and no call for democratic accountability that could not be avoided by secrecy clothed in the miasma of national security or yet another change in the law with retroactive effect. The Tampa incident in 2001 is often identified as the moment when it all really changed. I don't want to go into the history in detail, but to focus on a few aspects of recent Australian policy and practice which will show how, I hope, a principled approach would have been no less effective in achieving certain permissible policy goals, particularly protection, and far less costly in dollars and reputational damage. Changes are being discussed even now, not surprisingly after Wentworth, but despite the phenomenal cost in ruined lives, it seems to me there is little apparent readiness to recognise the harms done, whether to those directly affected, to many of those required or contracted to implement policy, to relations with countries in the region, and to Australia's standing in the world. And Australia's policy towards those arriving by boat over the past 10 years or so comprises a mass of legislation, much of it with retroactive effect, itself a sure sign of failed thinking earlier and always suspect in a would-be democratic system. Now, since 2012, no one arriving by boat without a valid visa will be allowed to settle in Australia, no matter their protection needs, their family or other connections. In certain circumstances, and if you plead strongly enough, you may be allowed to die in Australia, but that's as close as you'll get to permanent settlement. After 2013, Operation Sovereign Borders, and under Operation Sovereign Borders, those intercepted were transported to so-called regional processing centres, as we know, in Papua New Guinea, Manus Island in the case of single men, and Nauru in the case of women, children and families. None has in fact been transferred there since 2014. But notwithstanding the transfer and the involvement of other states, Australia remains legally responsible under international law for the treatment of those transported, including in matters of health, security and children's rights. It often half-heartedly pretends that it is not responsible, but I don't even think it's convinced itself yet. Now, this legal responsibility, this international legal responsibility, derives from the incontrovertible fact that Australia has exercised control and authority over those intercepted. It has checked their identity, their health and security. And it arises from the no less self-evident fact that no other state has formally assumed responsibility for those intercepted and removed. Australia, as we know, periodically invokes the sovereignty of Papua New Guinea, which is certainly party of the process, or the sovereignty of Nauru, which is also party, but whose independent as opposed to vassal status is, it seems to me, doubtful given its 95% dependence on cash handouts from Australia. Australia's continuing, if occasionally joint responsibility, is frequently confirmed by evidence of its control and influence over, for example, contracted services, including in refugee status determination, in health and welfare, and it remains legally liable, as on the mainland, for ill treatment and violations of, among others, the rights of children under the Convention on the Rights of the Child. The so-called regional processing centres were never that. They were never places in which refugee status would be determined promptly and fairly and solutions organised in the light of personal needs, circumstances and family connections. The region was not consulted. The assistance of other states was not sought until now, and neither PNG nor Nauru had any experience in refugee status determination or refugee settlement. The so-called Cambodia option was always another costly illusion, while New Zealand, until now, was consistently rebuffed, although it was considered good enough to help out with the Tampa debacle in 2001. And as we know, in September 2016, President Barack Obama offered to take up to 1,250 of those confined to PNG and Nauru, as was said at the time, and I quote, to relieve the suffering, which already included serious physical and mental pain, ill treatment, rapes, beatings, suicide, family separation, inadequate medical treatment, and the denial of medical assistance. And detention, too, raises other issues of international legal concern, and a particular feature of the present regime of immigration management is mandatory immigration detention, mandatory indefinite detention, which is prescribed by law for anyone who arrives without a valid visa, whether by sea or air. In April 2018, there were 1,369 individuals in immigration detention. Their period of incarceration averaged 434 days. 34% had been detained for over a year and 204 for over 2 years. Gratuitous and arbitrary restrictions on visits by family and concerned community activists introduced last year are apparently expressly designed to undermine yet further the dignity and self-respect of those detained. As far as one can gather from the limited published accounts, the detention and processing costs for boat arrivals for the period 09 to 14 increased from 118 million to 3.2 billion. Offshore detention, it's a phrase not now used for those whose freedom of movement is nonetheless limited to Manus and Nauru, is estimated to cost $400,000 per person per year, while monitored living in the community comes in at $40,000. And while there is evidence that lengthy indefinite detention increases the likely need for mental health care by up to 50%, there is no evidence to suggest that the cheaper options are any less effective in ensuring control and processing. And while security considerations may be relevant to the limited number of cases, the rationale for the more extreme response must be found elsewhere. Perhaps it's part of seeming tough, or maybe it's just vindictive. Of course, indefinite detention is by no means unique to Australia, and sadly, it commonly reflects frustration among state officials at not being able in practice to secure the removal to their countries of origin, or indeed of other states, of those who are not in need of international protection. But this in turn, more often than not, reflects ineptitude, it seems to me, and insufficient attention to relations with other states. The feeling, once again, that unilateralism is what matters, and that there is no need in migration matters to deal on a basis of equality and equity with other states whose citizens may be involved. But indefinite detention is inherently arbitrary, essentially arbitrary, as that term is understood in international law. And again, there is ample evidence, for example, from Woomera in the years 1999 to 2003, that it causes serious psychological harm, often resulting in physical injury. And this certainly accounts in part for the fact that Australia, as you know, has paid $70 million to settle 1,905 claims of ill treatment by those detained offshore. It has paid in addition tens of millions also for onshore claims, and many more claims are in the pipeline. No minister or civil servant, to my knowledge, has yet been surcharged for these entirely foreseeable costs to the public purse, to the people. Surcharging was a sanction used in the past in British administrative law at the local level for those councillors who had crossed the wire or done something wrong in the spending of money. It would certainly help, I think, in the accountability stakes if ministers and civil servants knew that they might be liable in some regard at least for the wastage of public money. Now, as we know also, there have been many transfers to Australia for medical reasons, thanks in no small measure to the persistence of the medical profession, especially here in Brisbane. But until now, practically every transfer has been resisted. It has had to be fought for case by case, necessitating costly and avoidable court proceedings when bureaucrats have sought to override expert medical opinion. Yesterday, The Guardian reported that the government had spent nearly $500,000 in legal fees over 3 months responding to court applications for urgent medical transfers. Sadly, though, the consequences of transfer are not necessarily that good. The situation of those transferred, though they may have received medical attention, remains precarious, and they and certain other classes in need of protection may be allowed to live in the community, but the general policy appears to be not to facilitate integration, but to perpetuate insecurity, to limit education and qualification, and to pursue to the point of destitution, the social costs of which once again will fall upon the community, and the rationale for such an approach beggars belief. So what would a principled approach look like, and how would it lead to goals consistent not only with Australia's interests, but with international obligations and international goals? So far, border management has been all about Australia, and that's not enough today when international issues are concerned. The stated aims of Operation Sovereign Borders and its associated practices have included stopping the boats, breaking the smugglers' business model, saving lives at sea, deterring onward movement in search of refuge. Has it worked? We don't really know, because accountability, narrative, fiscal or indicative, has been avoided. A boat from Vietnam arrived in northern Queensland a few weeks ago. The fate of those on board rapidly disappearing from the daily news. They were actually repatriated to Vietnam. But if one boat can come in, then why not 6 or 7? Or 16 or 17? And published government statistics list numbers of people in various abstruse visa categories which do not clearly indicate their manner of arrival. That might suggest border permeability, but we just don't know, any more than we know whether lives have been saved. We do know that Operation Sovereign Borders has included so-called turnbacks, and between December 2013 and February of this year, 33 boats and some 771 passengers are reported to have been turned back. Who were they? Did they need protection? Where were they sent? Again, we don't know. It may well be that the smugglers have gone back to their day jobs, but desperation is a powerful driver, and there is no evidence base to suggest that so-called deterrence is more effective in moderating movements than dealing with causes, whether root causes or the drivers of further displacement arising after first flight. An alternative, but still results-oriented approach, by contrast, would take and should take its lead from two complementary principles, that of protection and that of solutions. In my view, radical rethinking is needed, although I doubt that the political will exists to change all that needs to be changed in the short term. But first and foremost, governments, and not just the Australian government, but governments generally, need to step beyond the facile, populist but unrealistic conceptions of sovereignty that have characterised much policy making in the recent past. And they need to aim for practical approaches which factor in working cooperatively with other states, both on refugees and migration more generally. There is no good reason why Australia should continue to be fearful of people arriving by boat. The numbers have always been manageable, and if the appropriate international and institutional measures are put in place, they will continue to be so. There is also no reason to suppose that desperate people will stop taking desperate measures to escape intolerable situations, or to suppose that deterrence will stop them. While the smuggling business model may have been disrupted, there is no good reason why ordinary men, women and children in flight should pay with broken lives. So the movement of people between states will be a continuing phenomenon in the globalised world, and it would be far better that it were normalised, regulated more effectively, and managed consistently with international law, the interests of states and the interests of those on the move. The way ahead, however, will necessarily be one of short steps. There are alternatives. Many other states are exploring, not necessarily effectively, how to respond. But as in Europe, many are recognizing that they need to keep within the rule of law and a system of values if they are to get the results they seek and if they are to get the support of people at large. The about to be adopted global compacts on refugees and on safe, orderly and regular migration are, I see them as stepping stones in the right direction, premised on cooperation, not on loss of sovereignty or new obligations. But at the same time, there is no need to wait, and initiatives could be taken now. Firstly, with respect to Manus Island and Nauru. There are now some 652 people on Nauru, 541 of them, the great majority, recognised by Australia as refugees. 88 are pending a decision, and just 23 have been found not to be refugees. This is a population that today includes 52 children, after the transfer to the mainland yesterday of 27, including 11 kids. The most recent statistics for Manus are somewhat dated from May of this year, which indicated that 716 remain in PNG, most of them on Manus, some of them in Port Moresby. The humane response now, it seems to me, is to admit all those presently in PNG and on Nauru to Australia and to work for solutions from here on out, using any interim period to rebuild health and well-being and to set those refugees on the road to recovery. Durable solutions should be actively supported, either in third states, if that can be negotiated in appropriate cases, or in Australia. Priority must be given to family reunion, to ensuring that the best interests of the child are a primary consideration in every decision taken in their regard. And if there is no need for protection, if returns are problematic, then Australia will need to engage with countries of origin, but on a basis, as I've said before, of equality and equity, not confrontation and unilateralism. International law and international standards will govern, but there may yet be room to develop bilateral or regional agreements on regular migration, which normalise the process of return. And as for the lifelong ban on ever coming to Australia, currently being debated and seen by some, even some friends of mine, as reasonable and pragmatic, that is unprincipled. The people to be targeted by legislation have been intentionally and without due process transported by Australia to remote locations and confined indefinitely in conditions which, as policymakers would have known from previous experience, were foreseeably likely to result in abuse, in psychological and physical harm, not to mention breaches of international obligations. Such legislative targeting is reminiscent of acts or bills of attainder in the past. Once upon a time, and here's a fairy tale, the High Court of Australia ruled that even though not forbidden by the Constitution, such acts of attainder are unconstitutional, violating the separation of powers doctrine under which only a Chapter 3 court may wield judicial power, including the making of binding and authoritative decisions on issues relating to life and liberty. Would they decide the same way today? No matter. The proposal is unethical. So, do something about Manus, do something about Nauru, and then think about a pilot project for future process. With an eye on present and future regional needs, Australia should, it seems to me, or could develop a pilot project focusing, let's say, on the plight of Rohingya refugees, many hundreds and thousands of whom have found refuge for the time being in Bangladesh, while others have travelled farther afield. They are, without doubt, refugees, even if, sadly, Australia has been notably silent on causes and ethnic cleansing, and even in country, its representatives have often failed to support its allies and partner organisations in pressing for an end to violence, discrimination and detention. But Australia is not that far away from Bangladesh, from Myanmar, and hugging the coastline, the voyage is not so difficult. So working together with Malaysia, with Thailand, with Indonesia, Australia might be able to ensure that it is ready and able to support those countries if or when they are faced with an influx, so that Rohingya refugees can be admitted and assisted to find a durable solution if Bangladesh is unable for whatever reason to continue to carry the responsibility. And in anticipation of the real possibility that Rohingya may also arrive in Australia, then we need a domestic and regional strategy of protection and solidarity consistently with international law. This will require, amongst other things, it seems to me, a revised and strengthened local capacity to determine claims for status and protection promptly and efficiently. And that means we need a new legislative framework that carefully sets out in law the criteria for the grant of protection by reference to Australia's obligations and international legal standards. It will require access to process as of right, not at the discretion of a minister or civil servant. It will require decision-making by an independent statutory body. It will require, in particular, front-end loading to ensure prompt, effective and reasoned decision-making in a non-adversarial environment by trained decision-makers. And I would suggest also that it involve counselling, legal advice and representation. For we know, again from experience, that this is what leads to good decisions. In addition, no one seeking protection in Australia should ever be penalised by reason of their method of arrival or return or sent to any country in which they would be at risk or which is unable or unwilling to provide protection in accordance with international law. No one should be detained in the absence of good cause other than perhaps for an initial period for the purposes of identification, registration and documentation. No one should be denied reunion with their family or if a child separated from their parents, and no one should be denied medical care and assistance. Now, recognising that states in the region will also be affected by any further movement of Rohingya, Australia should consider now how it can provide political, financial and material support to countries admitting refugees. And if protection and treatment consistent with international law, including such solutions-oriented measures as employment and education are available, then Australia may be able to trade away its apprehensions to negotiate returns to first countries of refuge which are currently ruled out in law and practice. Experience shows that a high-principled approach will be called for. Because absent express undertakings, it needs to be remembered, and this is not always remembered by those devising policy, it needs to be remembered that no state has the right unilaterally to return or send a non-citizen to any country other than that of his or her nationality. And that's why the EU needed an agreement with Turkey on the return of Syrian and other refugees. Deficient as it is, the lessons of that exercise to date need to be recalled, in particular the self-evident linkage between returns, protection, security and opportunities for a reasonable way of life, including employment, healthcare and education for children. If Australia, for reasons of domestic policy, wishes to maintain its practice of denying arrivals by boat, then it will need to persuade the international community. It will need, in particular, to persuade its near neighbours of its commitment, nonetheless, to compensate them for the additional costs of providing settlement and solutions. And this is likely to require a considerable uplift in Australia's financial contributions, both to states bilaterally and to UNHCR and its commitment to resettlement. And finally, in stepping a little bit outside the brief for tonight, there is the question, the challenge of what I call loosely democratic adjustment. Australia's policy towards asylum seekers is characterised, I think, by a deeper malaise, which is the current imbalance between the executive, the legislature and the judiciary. And this has led to a form of what I call executive extremism, which no court today appears able or willing to curb. And it's led also to distrust more generally in the competence of politicians and bureaucrats and in their readiness to accept accountability. Now, this is clearly a long-term political project, possibly even beyond the Republic. But so is democracy. Democracy is a journey in which the three arms of government are not only in shifting balance and constant tension, but in which the democratic deficit can all too easily open up between government and government. And on migration and refugee protection, to come back to my subject, the people need to be on board, which is why community sponsorship programs like those in Canada have changed the perception of refugees. They've successfully tapped into the wellsprings of common humanity, and what is more, they have democratised the response to those in need of protection, which is perhaps why Australia is dragging its feet. It's the responsibility, nonetheless, of government, it seems to me, to ensure that Australian communities receiving the displaced have the resilience and the capacity to assure their integration and contribution to society. As the Canadian Minister for Immigration, Ahmed Hussein, remarked in a recent visit to UNSW, to get integration, you need to invest in integration. And no good ever came of forcing refugees into destitution because of the manner of their arrival. So finally, I want to leave with some questions. The question of exactly what Australia is doing or proposing to do with regard to present and future displacements of people which are inevitable. What exactly does it propose to do for those displaced by climate change and by slow or sudden onset disasters in the region? What exactly does it propose to do with regard to ongoing or incipient conflicts, particularly in the region? And what will it do about persecution and ethnic cleansing? Australia is a member of the Human Rights Council, but strangely silent. What a waste. Principles, then, and purpose. Thank you.